morning, Chief Judge, and may it please the court. Michael Davis here on behalf of plaintiff appellant David Briggs. I'd like to start my argument by first apologizing to the court. In my short decade of appellate experience, I've gone to a number of seminars where they talk about framing issues, and one of the key pieces of advice that you receive is no more than 2 or 4 issues in a brief. Our brief raises 11 points of error, 8 of which are preserved. But I beg the court's pardon. I believe when you look at the brief in whole, many of the issues are interrelated, and they all really relate to the core issue that was raised at trial. The defendant driver conceded at the trial below that she was negligent, and the key factual issue for the jury to resolve was causation, whether the defendant driver's negligence caused the injury in this case, which was death. The issues on appeal arise from several evidentiary errors, several trial rulings that really complicated this factual dispute by interjecting erroneous evidence and erroneous argument that really prevented the jury from having a fair and full opportunity to consider the core issues I've raised at trial. The first set of errors concerned the failure to wear a helmet. The helmet safety defense was never pled. It was never perfected during discovery, and at trial, no effort was really made to actually prove the elements of the helmet safety defense. In terms of the failure to plead, as Judge Casanova noted in Paul Gottlieb and Company.
You just lost credibility there for citing Judge Casanova. Can you be the first and tell it?
You know, in probable cause terms, I'm not a usually reliable source.
I was just cutting it off so that he wouldn't say it first. Please proceed, counsel.
Of course, Your Honor. But I think all of the court has agreed that in order for an affirmative defense to be presented at trial, it must be pled. And in this case...
Where was the harm here in this case? I mean, the DV was granted on that, wasn't it?
Yes, Your Honor.
So where does the harm resonate from? If I understand the trial court's ruling correct, was that it didn't want to instruct the jury to forget about all what you just heard, you know, that mythical erase your memory thing, because it went towards comparative negligence. Let's talk about that and tell us why the jury at that point in time was so tainted from the whole helmet issue.
Well, 2 responses. First, the evidence that was elicited in support of the helmet safety defense wasn't merely that he wasn't wearing a helmet. The defense also brought out the fact that Mr. Briggs had several helmets and didn't raise them. So it was very highly prejudicial. In fact, the defense also elicited testimony that 6 months before the accident, the doctor instructed him to not wear a helmet. The defense also elicited from the children evidence that it was safer to wear a helmet and not to wear a helmet. So in this case, where you had an unpled defense that should not have gone to the jury at all, that evidence coming in itself was prejudicial. When most people think of motorcycle, and people think of motorcycle as being a dangerous activity. The only thing that is probably more dangerous than riding a motorcycle is riding a motorcycle without a helmet. And there's a reasonable possibility that the jury, during deliberations and assessing whether the defendant's negligence was the substantial cause of the injuries, the jury could have concluded that,
But we have to assume, therefore, that the jury did not follow the instructions. Because comparative negligence is out of the case. So there's no need for any instructions. There's no need to say anything about the helmet. So what you're suggesting is that they considered evidence that was no longer in the case.
Well, yes and no, Your Honor. The court actually instructed the jury to base its verdict on the evidence that was received. So if the jury actually followed the court's instructions and based its verdict on the evidence received, that would include the evidence that he was not wearing a helmet. Moreover, Your Honor, the jury was also not instructed on comparative negligence. So the jury was never instructed that the helmet defense, the issue of whether he was wearing a helmet, the fact that he's being unsafe, the fact that he'd been warned, the jury was never told that that evidence went to the question of comparative negligence. And that was the key issue that led to the error in this case.
The trial was strictly based on causation, wasn't it?
Yes, Your Honor.
See, there was no place for that evidence in the first instance, is your argument, correct? There was no place for that whole helmet instance, in the first place, other than to show propensity of someone not wearing a helmet.
Yes, Your Honor, and I think that really speaks to the prejudice of this all. The court knows under the statute, 316.211, in order for the helmet safety defense to be at issue, the defense was required to prove at a minimum that he was required to wear a helmet under the statute. And the statute provides that you're only required to wear a helmet if you do not have sufficient insurance. And in this case, the defense presented evidence of the helmet defense without even making any effort to establish that he was actually required to wear a helmet. And it's the prejudice, it's the introducing a defense that wasn't pled, no attempt to be proven, that caused the issue. And for the defense, and this goes to the second issue, the defense requested that the jury be given a curative instruction. The curative instruction would have informed the court, would have informed the jury that it was not to consider any evidence of the seatbelt, of the failure to wear a helmet, and that's the second error that related to the admission of the evidence. The court refused to give that instruction, and then the defense wanted to inform the jury, the plaintiff wanted to inform the jury during closing argument, at a minimum that, you heard evidence about the failure to wear a helmet. That should not be a part of your deliberations. When you're determining whether Ms. Robinson's negligence was a substantial cause of his injuries, you should not consider the fact that he didn't have a helmet, and you should not evaluate whether his own negligence was, in fact, the substantial cause of his injuries, and you should not consider that at all. And that ruling, that prevention of that argument, was not supported by the law. The appellees, importantly, in their answer brief, have not argued that it was appropriate for the court to restrict the closing argument, and it is our position that the introduction of the evidence, the failure to inform the jury of the directed verdict, and then tying the plaintiff's hands behind his back and not allowing the plaintiff to inform the jury himself that directed verdict had been granted, and that those facts, those highly prejudicial facts, should not be considered by the jury individually and all together, created an unfair trial that requires there be a new trial.
If there were one case you would cite to the court that supports reversal based on the lack of the curative instruction for consideration of the helmet evidence and I guess the way the argument reads, it threads through, it kind of just was pervasive through the trial, what would the case be that is most instructive for the court to reverse for your client?
Specialty.
Tell me why.
Under specialty, the question is, we all agree that these are all errors, and the only question that the court has is, was it harmful error? Does it satisfy the harmless error test? And under the harmless error test, the defendant appellee must prove to the court beyond a reasonable doubt that there is no reasonable possibility that all of this evidence, that it contributed, and all of these errors, that it contributed to the jury's verdict of not liable. And just a review of the record, I think it's clear that there is at least a reasonable possibility. That is all that is required under special and DiGiulio, is a reasonable possibility that the failure to allow defense counsel to inform the jury of the directed verdict, the failure of the court to instruct the jury to disregard this evidence that should have never been entered because it wasn't pled, it wasn't brought up during discovery, and no effort was actually made to legally prove it at trial. The only question is if there is a reasonable possibility that that error contributed to the jury verdict, then reversal and remand for a new trial is required. Turning to the second issue related to the dormant MRSA theory. Defense counsel took the deposition of Dr. David, and just by way of background, Dr. David is a Yale grad, University of Chicago faculty, specialist in MRSA with 50 to 60 articles on MRSA. And he testified during the defense deposition with a degree of medical certainty that the MRSA infection and the MRSA bacterial string entered into the deceased body through the open laceration that in his mouth. So the testimony established at trial that there was an accident. The defendant driver ran over the deceased, the plaintiff's estate. That accident caused a laceration that was 3 centimeters long in the upper right roof of the decedent's mouth. And Dr. David testified that more likely than not, the MRSA bacteria entered into Mr. Briggs' system through that open wound, and he ultimately died.
What do we do with the evidence that suggests that there were no complaints by the decedent to his treating physicians?
Respectfully, Your Honor, that's just a misstatement of the record. The record is quite clear that Mr. Briggs, throughout the entirety, this is a 90-day, right? The accident happened on May 5th, and he died within less than 3 months. So the record is very clear that he complained of mouth injuries and mouth discomfort. For example, on May 12th, the Dr. Crespo, who saw him, noted that the sutures had not healed and that they're still there, and he noted Mr. Briggs' complaint of pain. On June 20th, and this is a month before, little under a month before his hospitalization and ultimate death, Dr. Crespo recorded that he had pain in the area of his mouth, and Dr. David, looking at that evidence, concluded that the zygomatic pain that he felt 30 days before his death was consistent with the cut not being healed. That's the evidence. The other evidence that Dr. David relied upon was also the consistent reviews of his body for skin lesions. So when a person dies of a MRSA infection, Dr. David testified that what medical professionals do is that they look at the body to see if they can find a portal of entry, a wound. And the testimony was that Mr. Briggs' skin was reviewed and there were no portals of entries that were discovered. So Dr. David, taking all of that evidence, looking at that file, applying his Yale education and his University of Chicago faculty experience, concluded that more likely than not, the only way that he could have gotten the MRSA infection was through the actual cut. Importantly, Dr. Crespo, who is a pain doctor who specializes in massage therapy, he also agreed at trial that this was the only way that the MRSA infection could have entered the body. So that's the evidence that came out. The defense missed the evidence and misrepresented what the evidence was, whether it was intentionally or not intentional. The fact of the matter is that the testimony or the argument that was advanced by defense counsel was not supported by the record. In our brief, we cite the portion of the closing argument. So this is trial transcript 935. Defense counsel argued as follows. Dr. David says that when the MRSA bacteria enters your body, it can stay there indefinitely and asymptomatic. It's there, it's in your body indefinitely. That one opinion, that one fact, that alone, without any more discussion by me, is the insurmountable fact that the plaintiff has to deal with. They have not. That was a complete misstatement.
There was no motion for mistrial at that point, right?
No, Your Honor. That trial counsel...
And the jury was instructed to not consider argument of the attorneys to be evidence, right?
This is correct, Your Honor. But I think the issue that requires reversible error is that Although plaintiff's counsel made the trial strategy decision to not move for mistrial, what plaintiff's counsel did try to do was to present Dr. David's relevant testimony. So one of the issues...
The summation testimony?
Exactly, Your Honor. So plaintiff's response was, we won't move for mistrial. We believe this can be corrected by actually presenting Dr. David's testimony. And what trial counsel did, recent trial counsel, as trial strategy, is he set up the video, which was admitted into evidence, and tried to show the jury the relevant parts of the testimony that would have shown that this is not the case. Just for the court taking records, this is Dr. David's testimony that resoundingly rebuts this argument, can be found at trial transcript 289 through about trial transcript 294.
Mr. Davis, you're a little bit over 15 minutes. I don't know if you want to reserve some time for rebuttals. I'm just giving you a heads up. You use your time as you wish.
Thank you, Lord. Thank you, Your Honor. And I'll just close briefly. So under Rule 1.330, the Federal Rules of Civil Procedure, counsel was clearly entitled to present that video. The failure to allow him to present the video created the prejudice that ultimately did not allow the plaintiff to fully present their case. And then also, Your Honor, I do want to put out the issue of the closing argument issue was raised in the motion for new trial, and also new trial was set based off of the failure of the greater weight of the evidence to establish the conviction in this case. For these reasons, Your Honor, we'd ask the court to reverse and remand, looking at these errors both individually and cumulatively for new trial. Thank you, Your Honor.
May it please the court, my name is Mihaela Kabilea, and I represent...
double duty today.
Yes, I am, Your Honor. And I represent the appellee, Rebekah Robinson. Before I address my opponent's arguments, I would like to summarize briefly for this court the theory of defense at trial. And it had nothing, absolutely nothing to do with the helmet non-use. The defense at trial was that Dr. David's testimony did not establish by preponderance of the evidence that the decedent's mouth laceration was the cause of death, the portal of entry for the MRSA infection that caused his death. The defense established at trial numerous other portals of entries. First of all, the decedent had a history of MRSA lesions. On November 2011, just 6 months prior to the accident in this case, the decedent was diagnosed with a MRSA lesion on his leg. In April 2010, he was diagnosed with a MRSA lesion on his earlobe. Dr. David did not know about the earlobe lesion. He knew about the MRSA infection on his leg, but he chose to disregard that. Number two.
One you mentioned on April of 2010, that would be April 30th of 2010?
April, it would be, yes, April 30th.
At the Florida Hospital of
Zephyr Hills, yes.
Okay, the medical record says draining abscess, infection, abscess, simple. The pages that I've looked on the record, 2,130, 2,128. Your caregiver has diagnosed you with an abscess. I don't find the word MRSA in any of those two pages.
Your Honor, it's at page 2120, and it's handwritten, and it's...
2120 handwritten? Okay.
Yes, it's
Thank
MRSA.
you. I had trouble reading some of the handwriting, but that's why I wanted to know where it was.
That's doctor's
Thank you.
strategy.
They have notations on them, not legible.
Right. So number two, the decedent also was a diabetic, injecting himself with Levemir injections up to basically May 31st, 2012. That's what the record establishes. These daily injections could have very well been the portal of entry for the MRSA infection. Number three, he had 2 cataract surgeries just 5 months and 6 months prior to the accident in this case. And all this information was relevant in light of the fact that Dr. David testified surgeries and any kind of open lesions on the skin, no matter how small, constitute portals of entry for the MRSA infection. And therefore, the defendant was able to establish all these other portals of entries before the accident and after the accident. So regarding the helmet non-use defense that my opponent is arguing has so tainted the trial that it requires a new trial. Your Honors, this issue was not even preserved, or the error was invited. 3 days prior to trial, when the motion in limine was heard by Judge Battles, plaintiff's counsel told the judge, Your Honor, I have case law on this issue. And the judge said, well, give it to me and I'll be happy to consider it and educate myself and make a ruling when we come back. Defense counsel, instead of doing that, said, Your Honor, we can decide this on directed verdict. So basically, this whole issue, this whole helmet non-use defense, or not even a defense, it was just a fact that was elicited during testimony, was invited by plaintiff's counsel.
What does that have to do with the lack of a curative instruction, or more importantly, an instruction to the jury to not consider the helmet evidence? That's two different things. What does that have to do with anything?
Well, first of all, the error was not preserved, was invited. But second, there's an ambivalent argument in the appellant's brief regarding the instruction. First, in the initial brief, appellant argues that the court committed reversible error, citing to Nesbitt, because it did not instruct the jury that a directed verdict on the issue of comparative negligence was entered. That instruction was never requested by trial counsel. And the only instruction requested was the curative instruction. And in the reply brief, appellant admits that that's the only instruction that was requested. But that kind of curative instruction is reviewed for abuse of discretion, and there was no abuse of discretion in this case because the trial court has the discretion to consider whether the argument would highlight and emphasize the prejudicial comment, and that's exactly what the trial court did here. The trial court said, I'm concerned about emphasizing the helmet. Now that the helmet is out and the directed verdict was granted, it's no longer an issue.
But the trial court's ruling was based on, well, it goes towards comparative negligence. That's the way I read that.
Right.
And comparative negligence had nothing to do with this. This had to do with causation.
It had nothing to do with it, right. And once the directed verdict on the comparative negligence issue was granted, that issue was out of the case. So it's really, and in addition to that, there was no reasonable probability that this fact elicited during trial would have tainted the verdict such that it requires a new trial, because the reference to a helmet non-use appears on only 11 pages out of 900, approximately 900 of trial transcript. And in addition to that, it has never been argued in opening statement by defense counsel as an affirmative defense or as anything. There's no reference to it. There's no connection between the helmet non-use and this accident. So the only issue and only defense argued was what the evidence established, that there were other portals of entries, and moreover that Dr. David, when he testified that the only portal of entrance was the laceration in the decedent's mouth caused by this accident, was not supported by the evidence because Dr. David didn't even know of the other portals, was not informed about the 11 mirror injections, was not informed about the 2 eye surgeries, and was not informed about the decedent's history of prior MRSA infections. So because of that, this whole issue has had really no impact on and the juries, as Judge LaRose said, the juries are presumed to follow the instructions. They were not instructed about any comparative negligence. They were supposed to determine whether there was causation in this case, and they determined, rightfully so, that it wasn't. And they were also instructed to accord whatever credibility they see fit to the doctor's testimony as an expert, assessing his credibility in light of all the other evidence in the case. And it appears that the jury has chosen to disregard that conclusion because objectively, medical records did not show that he, that more likely than not, the laceration in the decedent's mouth was based on was the portal of entry for the MRSA infection. So, as far as the dormant MRSA defense at trial, I have to point out that there was no contemporaneous objection. The defendant did raise, the plaintiff did raise a semblance of this argument in the motion for new trial, so arguably it was preserved, but it has to be analyzed under Murphy versus, sorry, I forgot the name of the case, International Robotic Systems, and plaintiff has failed to show that the argument was improper, it was harmful, error, incurable, and damaged the fairness of the trial. And there are a couple of inconsistency that I do have to disagree with appellant regarding what the record shows in terms of whether the lacerations has healed or not. We have not contested the fact that there is a particular time for the sutures to dissolve, which would have been anywhere between 5, I guess, and 10 days. It's in the hospital records. So the May 12 entry that my opponent referenced was only 9 days after the accident, and the fact that he still had pain in different parts of his body, that is normal, but we are talking about multiple opportunities that the decedent would have had to report to his treating physician and to Dr. Crespo as well as Dr. Palumbo that he had mouth pain, he had issues with his swallowing. Nothing of that sort was reported. And the fact that on June 20th, that's another reference that opposing counsel has, plaintiff, the decedent allegedly complained of zygomatic pain. That is, Your Honor, Dr. David's testimony and interpretation of the records. It's a page trial transcript 275. It's during his testimony, and the reported pain is not even specific. It doesn't say it's on the left or the right side of the face. The zygomatic arch is it's along the orbit, the eye orbit, and the laceration was above in the gum line. So it wasn't in the roof of the mouth as my opponent specified. So all these little details show that and the doctor's records show that there were no medical complaints, no complaints to his doctor. True, at trial there was some subjective testimony from family members that there was that the decedent had basically stated he still feels pain in his mouth and has discomfort. But the jury, once again, was instructed to assess the credibility, and the family members and his girlfriend were interested parties, whereas the medical records that were prepared contemporaneously showed no such complaints to the doctors. And the other thing is, and the other inconsistency in appellant's brief is that right when the decedent was admitted in the hospital with the MRSA infection, there was testimony from Dr. Hippolyte that the decedent was examined by 2 doctors. One testified that there were no lesions on his skin, but the other one also testified that there were no lesions in his mouth. There was nothing that was observed, and the mouth was examined, but there was no such wound found, nothing that would indicate that his laceration had not healed. So in terms of excluding the testimony at trial, the video deposition played back of Dr. David's testimony at trial because to allegedly correct the so-called Mercer-Dorman theory of the case that defendant put forward. There was absolutely no reason to do that. The trial counsel was allowed to read the deposition extensive portions in the trial, in the closing argument, and the record reflects that he did actually do that on page 905 and page 906. So, and after that, he was able to summarize the testimony of Dr. David on multiple occasions. So, really, Dr. David's testimony supported the defense theory that MRSA can stay in the body for months and can have no manifestations if some patients tolerate that. And there was no testimony to the contrary that the decedent was not one of those patients who could tolerate that. So a trial, through the entire trial, that's what the defense tried to bring up. The helmet non-use was a simple fact, and we would ask that this court, we stand on our arguments on all the other issues, and we would ask the court to affirm the jury verdict and the trial court's final judgment.
Thank you very much.
May it please the court, I want to go to start with issue 1. This is the question, the argument in terms of invited error with respect to the evidence of failure to wear a helmet. Our reply brief responds to this, and it quotes the full context of the argument. The motion in limine was to exclude it based on the failure to plead. At the motion in limine hearing, that same argument was made. Counsel also addressed the merits, and the court disagreed on the merits. And with respect to the merits of the defense, that's the only thing that counsel said, we'll wait to JOA. And in fact, as we note in our reply brief, when the evidence was first introduced, we renewed our objection for it not being pled. Also, I want to turn to the MRSA issue. And I think if you open our briefs to the second issue, we quote Dr. David's testimony on this point. Dr. David is presented with a medical record of Mr. Briggs having a MRSA infection in November of 2011. And defense counsel basically asked, could it have entered into his body in 2011 and remained there dormant until July of 2012? And Dr. David was very clear in dismissing that argument and saying, no, that's not how it works. If the MRSA enters your body, right, we all know bacteria enters your body, your white T cells will always fight to try to get rid of the infection. And when the body fights against the infection, that's when you get the boil, you get the abscess. So Dr. David clearly testified that there was no such thing as dormant MRSA. Our reply brief also addresses the Levemir issue. There was no testimony that he had daily Levemir injections. He had no insurance and could not afford it. The Appellate persists in continuing to misunderstand the record. In this case, the court should remember the defendant presented no contrary defense expert testimony. They did not even produce a report. They produced nothing in the record during discovery, at trial, in the pleadings, at all indicating that they had a doctor who would give an opinion that was different than Dr. David. And that was the sole testimony here. So we believe that all of the issues put together really do establish. And finally, I want to go to the failure to give the curative instruction. The court asked for a case. And I think the best case that we cite in our brief was ITT Nesbitt Incorporated versus Valley Steakhouse of Fort Lauderdale. It's a 4th district decision. It's cited in our brief. And in that case, the court concluded that after the court directed a verdict on negligence, it was prejudicial error to not inform the jury of the granting the directed verdict, because it makes sense. We want the jury to consider all of the evidence that has been presented, and whether they're doing it based off of the law, whether it's based off jury nullification, the jury bases their verdict on the facts. And the facts that go to the jury in deliberation are of the utmost importance. And in a case like this, where you let in evidence that should not have been let in, you do not give a curative instruction, and then you tie the plaintiff's hands behind his back and do not allow the plaintiff to bring that fact up. That's enough under ITT v. Nesbitt, under Judge Castroneva's decision, to require that there be a new trial, and the Mercer issue just only adds to it. Unless the court has any further questions, we'd ask the court to look at our reply brief that replies to all of their arguments, reverse and remand for a new trial. Thank you, Your Honor.
Thank you. Thank you both. Mr. Cuney and Mr. Russo, always good seeing you here, and thank you very much for letting your colleagues argue this case.